and you are here today for Presumptive Parole, New Jersey's experience and the need for continued reform. Welcome. I'm going to start just by letting everyone know, again, we record our events, so this will be posted afterwards on our YouTube page and on our website. And this is part of a speaker series this semester focused on the myths of public safety with a feature on parole. So if you missed our earlier events in the semester, you can head to our website to screen those as well. We have 3 more events this semester planned. Next week's is a return to kind of special topics speaker series where we're featuring research done by affiliates of the program and students whose work we funded in the past. The focus next week is on reimagine community safety with a particular case study of public housing development in Boston and their structures they built outside of a typical policing infrastructure. And following that, on April 26th, we'll have LaToya Whiteside from Prisoners Legal Services of Massachusetts and Jasmine Borges, who is an organizer and activist with the Massachusetts Bail Fund, to talk about prison classification and disciplinary procedures and the ways that those impact eligibility for parole and the racial disparities that are produced through that process. And then finally, our last event of the semester, and this is a change, is on May 10th. It had been scheduled for May 3rd, but we've pushed it one more week. And it's with Rachel Barco from the NYU School of Law to talk about executive mercy and clemency and around the country. So please stay tuned for those events. To kick us off for today, our typical way of doing these events is as a community meeting space. So, we would welcome your participation. We're going to start with Joe and Alicia. I'll give you their bios and then we'll have a moderated conversation, but we always leave time for questions. And if you have burning questions that you want to ask at any point, please feel free to utilize the chat. We will be taking those questions by allowing you to ask them yourselves in sequence at the end. But if things come up in real time, we're happy to also pause to answer them as we're going. And without further ado, I'm going to just do a quick skim of your bio. So we've got with us today Joseph Russo, who is the first assistant public defender of the New Jersey Office of the Public Defender. Joe served as the deputy public defender of the OPD statewide appellate section for 4 years, and then as the deputy public defender in the Hudson Trial Region for 7 years. Joe worked for many years in the Somerset and Warren Trial Regions. He's been all over the state, and he is the only public defender in OPD history to serve as the managing attorney of both the appellate and trial sections. In addition to his extensive trial experience, he's argued many important cases before the New Jersey Supreme Court and Appellate Division, which is the intermediate appellate court in New Jersey. He argued significant parole cases as well, which we're going to hear about today. And you can read about all those specific individual cases on our website. Joe was named the 2017 Criminal Lawyer of the Year by the Hudson County Bar Association. He's the founder and co-chair of the Statewide Parole Project, which we're going to hear a lot about today, co-chair of the Amicus Committee, co-chair of the Resentencing Committee, and for several years co-chaired the Forensic Science Working Group. Joe serves on many other associations throughout the state of New Jersey, and we're really grateful to have the opportunity to have him here today. And Joe and I worked together when I was an attorney at the Charles Hamilton Houston Institute at Harvard Law School a couple of years ago on a particular case that I'm sure is going to come up today in the case of Cindyada Okoli. Alicia, who we're also delighted to have with us here today, served as the Assistant Deputy Public Defender in the Lifer Group and Parole Project of the New Jersey Office of the Public Defender. Alicia earned her degree from Bennett College and then attended the Howard University School of Law, where she later served as a special assistant to the dean. Alicia went on to serve in the Cumberland Vicinage of the Superior Court of New Jersey as a law clerk to the Honorable Julio L. Mendez. In 2003, she joined OPD, where she has served as both trial and appellate counsel and argued significant cases before the New Jersey Supreme Court concerning a range of issues: illegal searches and seizures, the right to remain silent, and the improper prosecutorial use of experts in drug cases. Her current work focuses on gaining sentencing relief for young people sentenced as adults and obtaining release opportunities for those sentenced to life behind bars or lengthy carceral terms. Her practice is informed by the words of the great civil rights attorney and iconic dean of the historic Howard University School of Law, Charles Hamilton Houston, who famously said that a lawyer is either a social engineer or a parasite on society. Thank you both for being here today. We're really excited to have you, and I figured we could start off with a little history of New Jersey's parole statute. So New Jersey adopted presumptive parole back in 1979. Can you give us some context for why the state developed a presumptive parole framework?
Sure, Katie, but before I do that, I have to give you one of my favorite quotes. It was said by Ted Kennedy at Obama's, I think it was at the convention when President Obama was nominated to be president. The work goes on, the cause endures, and the dream shall never die. So it's Ted Kennedy, but it really is a combination with a lot of motifs from Martin Luther King. So yeah, getting to your question, Katie. So actually the 1979 Parole Act, which gives a presumption of parole unless the board can establish by preponderance of the evidence that the incarcerated person up for parole is likely to recidivate, it was really a big deal. And the question is, how does that play out in real life? But how did the 1979 Parole Act come into play? How did it get passed and signed by the governor? It was a direct result of the riots at Attica Prison. And there was recently an amazing documentary. There was the 50th anniversary of the riots at Attica. And as you know, that lasted for a few weeks. It ended up with a lot of deaths at the end of the day. But also we had riots here in New Jersey at Rahway State Prison, the very place where Reuben Hurricane Carter was housed for many, many years, who had asserted his innocence up until the time he died. But Rahway State Prison is a legendary prison from the 19th century. I think the late 1800s it came into play. But there was extensive riots at Rahway State Prison on the heels of the riots at Attica and 50 years ago. And as a result of that, the New Jersey legislature said, wait a second, we need to give some type of predictability and consistency to the parole process. That is, that people who are in prison, who are doing well, who are taking part in institutional programming, perhaps going to college or obtaining a trade, or obtaining their GED, but doing well and are well behaved, we need to give them an incentive that they can in fact get out, that it's not the end of the road, it's not a de facto death sentence. So to answer your question, the backdrop is the riots at Attica, the riots at Rahway State Prison, and it was a methodology by our legislature. It's in the legislative history. It was a method to make the parole process more consistent, more predictable, and most of all, more objective, not relying upon subjective, speculative criteria, and not to focus simply on the horrific nature of the underlying crime. So that's how the 1979 Parole Act came into play. It was a sea change in New Jersey because for the first time, there's a presumption in favor of release, with the burden on the board, as I said, to establish that the inmate was substantially likely to commit another crime upon release. But that's, as we will talk about, that's not how it has played out, of course, in reality in New Jersey.
Yeah, absolutely. So, Alicia, I know you're going to have many things to add. I might just pivot us because Joe just teed up the next question, and then we'll let you take the lead on this. The expectation of presumptive parole, right, is that it should increase the paroling rate of the state parole board, because now the presumption is release, right? That's the default, and the board has to prove otherwise in individual cases. Is that what happened in New Jersey? Are there particular trends around parole hearings generally, or life of parole hearings in particular, that are out of step with that expectation? And how has OPD tried to obtain data to document those trend lines?
So what we know is that although the Parole Act that we're talking about is in the 1979 Act, there was subsequently a 1997 Act that coincides with a different sentencing scheme for what are considered violent crimes. But for the 1979 Act, which many people who are currently serving are still serving under that act, by the 2000s, we see that the rate of parole granting is decreasing, right? And this is in a system where there's supposed to be a presumption of relief. Essentially, as Joe just said, unless the parole board can show that you will commit another crime or you will recidivate, then you are supposed to be released. And the Sentencing Project is an entity that does all types of research, but they did research up until 2013 that showed that the rate was dropping. And by 2013, we have a grant, at least for those who have the potential for life sentences. So these are people who the top number may be life, but the sentence will say things like must serve 30 years and then you'll be eligible for parole. And then the parole board decides if you're released or not, right? Or must serve 35 or 40. For some people, it was even less than 30. And so what we know is that for those individuals who are serving the potential for life, the grant of parole was down to about 13% by 2013, right? And again, this is in a system that has a presumption of release. We, as an agency, saw that our clients, or former clients, were telling us that they weren't being released. Now, let me just take this moment to say that we found this out from individual clients, but we also found this out because at the same time, because of some US Supreme Court cases and some New Jersey cases that began around 2012 and moved forward until 2022, juveniles who had been waived up to adult court, so being prosecuted as if they were adults, even though they are not, and were receiving very long sentences, became eligible for resentencing under these other cases. But that brought something to our attention. Some of these children who were now adults, who we were representing, were already eligible for parole. And we were wondering, why haven't they been paroled, right? We're going to have these other hearings, but why haven't they been paroled? And we kept finding these situations where again and again, they had been denied parole. So that was also bringing this to our attention. And so we then, Joe Russo and another one of our attorneys who's now on the bench, so is no longer with us in the office, went and did an OPA request, an Open Public Records Act request, and asked for the data they asked for it at the end of 2019, the beginning of 2020. So they asked for it for the previous 5 years. So the data we got confirmed all of our worst fears. And what we learned is that those who were facing life in prison were being paroled at a rate of less than 9%. Again, in a system that has a presumption of release. And so that's how we got the information. That's why we got the information. And we then decided what to do with that information.
Yeah, super helpful. And I think looking at that sentencing project report is really illustrative because one of the, things you can see is that the paroling rates for lifers in particular could have been as high as in the 60s, right? 66% in 1985, according to these data. And the idea that for offenses that haven't substantively changed, right, the people who have committed them have nominally changed, right? It's different individuals, but the sentences themselves haven't changed, and yet we're seeing a dramatically reduced rate by, factors of 10 almost in some cases. So this leads us then to our next question about, are there particular things about New Jersey's parole statute or the culture of the parole board or parole agency that are in tension with the idea of a presumption of parole? Kind of what made it so that this statutory change didn't actually have the intended result?
Yeah, that's a very good question, Katie, and that's something that we've discussed. Several reasons. First and foremost, 97 or 98% of individuals who go before the parole board who are eligible for release and have they're cloaked with the presumption of release are pro se. They do not have a lawyer. And you would say, well, what is going on here? Because they receive oftentimes these future eligibility terms, which means you go before the parole board, they say, you're not ready for parole. We're going to give you a hit. We're going to extend your eligibility for parole for the presumptive term is 27 months, but they often go way beyond the presumptive. And they give hits of 3, 5, 10, 15, 20. One hit we saw was 30 years. And so the next time you're going to come before the parole board is many years from now. So what's that about? So there is no right to counsel in New Jersey before the parole board. No constitutional right to counsel under the federal constitution or the New Jersey state constitution. And I might add, the state constitution in Jersey has been interpreted very liberally, giving our citizens much greater rights than the federal constitution provides. So one judge in a dissent many, many years ago said that at sentencing, you receive modern due process rights. When you're before the parole board, you barely get a horse and buggy. And that is true in New Jersey, unfortunately. Although things are starting to change through some of the case law that we're developing through the Office of the Public Defender's advocacy and certain cases that have statewide impact. But the bottom line is you do not have the ability to have an advocate next to you, a lawyer or a non-lawyer, during the parole hearing itself. Now, why does that matter? I would like everybody to think about this. We have a diversity of backgrounds and diversity of professions on this webinar here. Let's think about that for a moment. Can you imagine if you went before a sentencing judge on a major felony case and you might be sentenced to 10, 15, 20, or 30 years and you do not have an attorney? Why should it be different, in my view, when you're before the parole board on a homicide case with a presumption of release and you do not have an advocate to produce an expert report, to cross-examine any experts, any psych reports? That's a real problem. But to add insult to injury, Katie, and everybody here, to add insult to injury, psychological reports must be issued. The person going up for parole must be evaluated by a psychologist under New Jersey statute in a homicide case before they're even considered for parole. Now, that psychological report is never given to the incarcerated person before the parole board. That's considered a confidential document. And even if you have counsel, you have to sign these consent protective agreements or consent protective orders saying the lawyer will maintain a confidentiality of it and not share it with the client. So you have two hands tied behind your back when you go before the parole board, and it puts a real wedge between the attorney and the person going before the parole board. And I'm talking about this 2 or 3% cases where they actually have an attorney, where they can afford an attorney. But again, even if you could afford an attorney, even if you're a billionaire, okay, you cannot have the attorney physically present before the parole board. And that is a major, major, major problem. So the withholding of confidential materials from a pro se parole applicant, including the psych reports, is a major, major fatal flaw in the New Jersey system.
And Joe, to add to that, well, first of all, to elaborate on that issue, the two that you just talked about, the lack of counsel and the confidentiality issues, they play into each other. And I do want to make this very real for people because, right, this is like theoretical. Okay, I see why in theory this would be a problem. So I want to give you an example that we actually have from actually 2 examples from cases that we've worked on where the person did have counsel. And again, this is less than about 5% of people going up for parole have counsel. These individuals had counsel. Counsel had to sign confidentiality agreements or non-disclosure agreements with the client. So we couldn't share it with them. But, you know, in one situation, remember, the vast majority of people are not going to have access to the records that are being used against them by the parole board, and they're not going to have anybody to look over them as well. So in one case, one of our lawyers and I were sitting at night reading through, the denial that the parole board gave. We finally got, this attorney was so diligent, and she finally got the psychological records after signing the paperwork saying she wouldn't share them with the client. And we were going through the psychological evaluation that the parole board themselves had commissioned. This is their, the person they hired to evaluate this person. And what we realized is that the denial, that the letter that the parole board gave her client was supposedly citing the psychological evaluation. But when we went to the psychological evaluation, we saw that portions of sentences were reproduced. Note I said portions of sentences, so that when they were placed in context of the words in the report, they meant things totally opposite, or at least things that did not comport with what the report writer actually said, right? But how would the client ever know that, right? And in another situation, we viewed the psychological evaluation all to learn that the evaluator was using an outdated test, right? Again, how would our client ever, first of all, have the wherewithal to know? We didn't know it was an outdated test. We had to go to professionals to find that out. But our client wouldn't even know what test was used necessarily, may or may not know. And so these are very real issues. And I want to note that in both those cases, those individuals, I'm not going to identify them, but they had been in prison for decades, right? And so these decisions, and they had each been denied before. So these decisions had real life consequences for them. And then I just want, I'm sorry.
I'm sorry, Katie.
No, Alicia, continue. Go ahead.
And then I just wanted to raise 2 other issues that contribute to this name and only presumptive system. And that is the number one is the ability of the parole board. They have certain factors that they can consider. There are about 24 of them now, but they can consider and routinely consider the facts of the crime. Now, at first blush, people might knee-jerk reaction say, but yeah, of course they're going to. But let's think about that in our system, in our criminal disposition system. Juries are the judges of the fact, and judges are the judges of the law, and judges impose sentence. We do not have the death penalty in New Jersey anymore, thankfully. And in the death penalty context, a jury imposes sentence. But in all of the criminal context, it is the judge that imposes sentence. The judge imposes sentence based upon the range of legal sentences that the legislature has made available. So the legislature says, for this crime, this range of time is appropriate, right? You sentence within that range of time, unless there are some extenuating circumstances. The judge is also, under New Jersey law, and in most states, supposed to sentence keeping in mind what all the laws are that affect the sentence. So the laws of parole in that state, the laws of, any other type of post incarceration requirements and all those different things. The judge is supposed to keep in mind, unless they're called just collateral consequences, which we won't get into, the judge is supposed to keep these other things in mind. So a judge is sentencing someone in New Jersey with the idea that we have legally presumptive parole, and that says that I'm going to sentence you to a minimum period of time that you must serve, or no minimum time, but at least, you will serve a certain period of time. If I give you a minimum period of time, at the end of that time, you will see parole. And if you have done what you're supposed to do, if they cannot prove that you will commit another crime, you will be released, right? That's the system. And judges have set the sentence based on that. Why is it then that, and remember, the judge sat in the trial or took the plea, and so knows the facts of the case and agreed to accept that plea offer, or to agree that the evidence presented was sufficient at trial to sustain the conviction and then sentence you. Why can the parole board, who didn't hear that evidence, who are not mandated by our Constitution or any other laws of the state to be the sentencer, why is it that the parole board gets to take into account the facts of the crime to determine if you were going to stay in prison or not, when the only question they're supposed to be answering under the 79 Act is whether you will recidivate, meaning commit another crime, or if you're under the newer 97 Act, if you have not complied with your rehabilitation or will not comply with the rules of parole when you're out. All of those factors look to things that occur after the sentencing. The judge sentenced, that is his or her role, and the parole board should not be able to usurp that role and become the uber sentencer.
Well, and I'll just add, and I'm so sorry to interrupt you, but the statute says by its own terms, the punitive portion of the sentence has been deemed served by the time the person gets to the parole board, right? So the judge sentences somebody keeping in mind that sentencing is supposed to represent a series of values, right? Punishment, deterrence, rehabilitation, right? And the punitive portion of that sentence is supposed to have been deemed served by the time somebody gets to the board. So sorry to interrupt, but just wanted to
No.
add
I'm so glad you to point that out, because it's a natural, people will say, well, of course they're going to look at the facts of the case, but no, that is not their role. That's not their job. The judge already took that into account when he or she found the aggravating and mitigating factors and decided what sentence to impose.
Yep, and that's one of the things that happened in the Epoli case.
Yes.
I had the opportunity, and the transcript is not confidential, but of course, when I argued as amicus on behalf of the Office of the Public Defender in the Sundiata Coley case, to refresh people's recollection, that was the shooting involving, unfortunately, a New Jersey state trooper in around 1973. And one of the things that Ray Brown said, actually extracting it from Katie's brilliant brief, was that the parole board, and I'm simplifying this, of course, but the parole board froze Sundiata in 1973. It didn't matter what Sundiata did in prison. And by the way, he received a Lifetime Achievement Award, had an exemplary record for about 30 years, and he had done some great things in the prison system. But I want to point something out about the transcript. This man, when he went before the parole board, he was eventually released by the New Jersey Supreme Court in a 3-2 decision, a hotly contested dissent. He had been in prison for 49.5 years and was 85 years old at the time of his release and poor health. So the transcript of that 6.5-hour hearing, that when he went before the board, I think he was in his mid-70s, really was an interrogation. It was an adversarial hearing with unfounded theories by the board members disguised as questions. And one particular line of questioning, and I think Katie, you'll remember this, was they wanted him to speculate because he denied for almost 5 decades that he was the shooter. He denied that, but he was extremely remorseful, recognized his role as an accomplice. But because he denied that he was the shooter, that was held against him as an aggravating factor. So they asked Acoli about 20 times in the transcript, 20 times, we would like you to speculate regarding how the trooper got killed. And he kept saying, I don't want to speculate. Finally, after he was asked many times, you can read the Supreme Court decision, he said, okay, if you want me to speculate, I'll speculate. The trooper was killed by friendly fire. And then one of the key reasons in denying Sundiata Acoli parole was that he speculated, that he engaged in speculation regarding the crime. When the board invited him to speculate, read Justice Albin's brilliant opinion. So not only did they ask him to engage in speculation, what he did, and then he considered that an aggravating factor, but they placed all kinds of undue emphasis on his ancient crimes, and they cherry-picked portions of the record. They cherry-picked portions of the record that supported the predetermined conclusion that he was likely to recidivate, and they overlooked tons and tons of compelling mitigating evidence, and they undervalued a lot of mitigating evidence. But I want to point out this. It's a 286 total transcript, 286 pages. How many pages do you think that they focused on his rehabilitation and his institutional progress? 12 pages were dedicated to his rehabilitation and institutional progress of 286 total pages. That I calculated before argument was a mere 4% or 16 minutes of the 6.5-hour interrogation, only 16 minutes. So 96% of the entire hearing was dedicated to an obsessive focus on the nuances of the underlying crimes and historical events. And if you take a look at Judge Rolstadt's dissent in the appellate division, that's how it got to the New Jersey Supreme Court. He stated that the board, quote, should not place undue emphasis on any one factor, especially the crime that the inmate committed. And so that's some background on that case and how the board does not engage oftentimes in an objective review. And getting back to the standard that we talked about, predictability, right? With this presumption of release, there should be some predictability. You really should take a look at, if you have data to support a de minimis risk of recidivism, you should use that data. And some of that data is the age crime curve, right? We know, right? As folks get older, the risk of committing a crime dramatically decreases. That's called the age crime curve. We know from the brain science that juveniles are subject to very risky behavior, engage in impetuous, risky conduct, right? Because their conduct is often part of being very, very immature, not appreciating the risk that they're taking. And that the brain matures at age 26. So after age 26, you also see a precipitous decline in recidivism. We also know the data regarding education. Many of our clients get college degrees in prison or 2-year degrees. Sometimes they get a master's degree. And we know that if you get a 4-year degree in prison, the risk of recidivism is somewhere between 5 and 7%. A master's degree, it's less than 1%. But these are the kind of things that the board has to take a look at because it's an objective analysis, not just a subjective analysis, in making a determination as to whether or not a person should be released with the presumption of release. And one of the cases in New Jersey, this case called Cosmin, K-O-S-M-I-N, stated that the board cannot conclude that a person's insight into his criminal behavior is impaired because he will not admit that he was the actual shooter. And that's one of the things they did in the Acoli case. He maintained he was an accomplice, maintained for many, many years. He was truly remorseful, but without question, he was remorseful for this very, very, very unfortunate crime. But they utilized his version of events and trying to get inconsistency in the version of events as a basis to deny parole, even though Acoli had served the punitive portion of a sentence decades ago.
And I know we're going to move on to the next question, but just when Joe was talking about the parole board and the problem that we saw in cherry picking, because that is one of the ways that we've seen, now that we're involved in some of the cases, one of the ways we've seen that they've made presumptive release on parole something that is in name only in many situations, is by their selective use of factors or focus on factors, but also of certain facts. Now, I want to tell you a story. Again, I'm not going to reveal the name, but we are aware of a situation with someone who was denied parole. He or she is not serving a very lengthy period of, like, they're not serving a 30-year sentence, right? But they were denied parole. And one of the things, there's a checklist that they kind of have on, why they denied you, and what factors they found and didn't find. And one of the things that they listed as a reason for denying the person was that he or she was removed from a community placement. Now, that's kind of like what most of you would know as a halfway house, right? And so you could see why that would be an issue, right? Wait, if we put you in a halfway house and you couldn't make it there, then we're not going to release you on parole. You could see why there'd be a nexus between removal from the halfway house and the decision not to parole. Except what the parole board neglected to put in was why he was or she was removed. The person was removed from a community placement. They had a job because they were on work release, meaning they could leave during the day and go to work, and they have to come back to the halfway house. And one day while they were at work, they passed out and they had to take them to the hospital, where they discovered that they had a terminal brain tumor. And the halfway house said, we can't handle this. They're going to have to go back to prison because they're going to need radiation or chemotherapy on a regular basis. We don't get involved in that. We don't even want to keep somebody who just has to take insulin every day. We surely aren't going to deal with this, right? And again, remember, the vast majority of the halfway houses are privately run. They're for-profit situations. And so they have all kinds of reasons why they wouldn't want to deal with that. Do you think it was ever listed in the parole board's denial that this person was removed from the community placement because they have a terminal brain tumor that requires treatment so that they can extend life as long as possible? No, they didn't, not in their initial denial. And then they had the unmitigated gall, and I would say actual cruelty, to list in their denial that for the next go round, the person just needed to take some more classes. The person with the brain tumor, the person they don't know will be able to comprehend the information conveyed in a class, or how long they will be able to do that. And so when we are saying, this cherry picking, this is not, we're theorizing this as a problem. We have real life situations. Here is a person who may die in prison, who may not be getting all the care that they should be getting because the parole board decided it was just fine to ignore or to purposely mislead in their paperwork what the situation actually was. And also, by the way, the guy with the terminal brain tumor or the woman with the terminal brain tumor, how concerned are we that they're going to recidivate?
Yeah, absolutely the right rhetorical question. I think we all recognize that as a rhetorical question in this group. And I really appreciate the way that you both outline, the specifics in terms of individual cases, and then also how those represent broader systemic problems, right? How the fact that the parole board uses, cherry-picked information and then also subjective factors that don't even appear in the statute sometimes, right, is something we also talked about in this context. And I think we can get into that more a little bit later. I think the next phase is for us to identify, how did you all start working on this issue, right? So you've got the data and you're working on some juvenile lifer cases, right? That's part of the history. Tell us about, when did OPD start the parole project? When did the New Jersey Office of the Public Defender put resources behind this? And what are the goals of the project more broadly?
So it's really important for us to first say that the idea for the parole project started germinating in lots of people's hearts and minds, but I'll say in Joe's mind, and in some others, in 2019. Now, you read in the bio that Joe was the deputy of the Hudson Trial Region, and then the deputy of appellate. And for those on the call who have never done appellate work or are not attorneys, appellate law is based very much on what's in the record. What was said in court, what do the papers say? And so in theory, it's possible to do an appeal and never actually meet your client. You should not do that. That is not a good thing. But your client's version and things like that don't matter in appellate in some aspects, because all the court is looking at is the record, right? It should matter to us, but the court, it's very hard to get in things that weren't in the record before the court. That creates a situation where a lot of times appellate attorneys are siloed and don't interact with clients in the same way that a trial attorney would. And so Joe was adamant that the attorneys go visit clients who were inside. When he came to appellate, he wanted attorneys to go inside and to visit and see, just talk to people who were serving sentences, our client population. And so Joe had us go in the office, the appellate section, 2 different times. We went in 2 groups to one of the state prisons. And while we were there, we met with the lifers group. And it's very important for us to say that as much work as we have done on this issue, it was the gentlemen and the ladies inside, the ladies were at a different prison, who brought to our attention the systemic issues, who gave us ideas about what they saw being repeatedly used to deny people parole, or their friends and people who had formerly been inside and were released to deny them discharge from parole if they were on parole. And so they brought those ideas to us. And then at the same time, I told you we got those statistics. We got them at the beginning of 2020. We all know what happened in March of 2020. The pandemic hits, and one of the things that we do, because at that moment, New Jersey has one of, if not the highest, carceral death rate from COVID. And there were a lot of reasons that was the case. And so we are, working with the ACLU and other legal partners to do what we can to literally thin the prison population so that our clients stop dropping dead, right? And one of the things that happens is the governor signs an executive order, and a lot of people know about COVID credits, which were extra credits you got, as if they were counting more days than you were actually in to get you out earlier, right? But there was another part of that executive order that called for the parole board to review parole cases they'd already reviewed, and to see if, hey, given that now, I know last year you looked at this person, but now, the world situation has changed. There's a deadly pandemic. People are at risk just because they're institutionalized. Does that change your calculus at all? And the individuals in our office who were charged with kind of looking at those things and reviewing what was happening were noticing that the parole board still wasn't releasing anybody after a review. And so we went, well, wow, even when our clients they know their lives are on the line, they're still not willing to budge. And so all of that together, again, with our juvenile work as well, led Joe and some others to say, okay, we have to do something. We are public defenders. We defend, and we cannot let this continue. So Joe, I know you want to then go on and say what, specifically, that's how the seeds of the parole project, but then how we actually started it. Joe, I think you're still on mute.
Sorry about that.
Okay.
Yeah, it's number one, this is transformative work because we're dealing with lifers. The great majority of which, not even the great majority, probably 80 to 90% of lifers that I've met have transformed themselves in prison. And typically that's right around the age that the data and experts like Bruce Weston, I'm not sure if I'm pronouncing it right, but say that, at around age 26, you mature.
That's right. Kennedy School, PCJ, a former affiliate. Yep, that's right.
Exactly. And normally that's what we see. And I just want to tell you a quick story about that meeting, those 2 meetings we had with the lifer group, formerly known as the Scared Straight program. But they realized, decades ago that one lecture of somebody trying to scare you straight really doesn't work. It's an evolutionary journey. And so when we went there for the first time, there was about 8 or 9 lifers. There was a Q&A for about an hour and a half after we got a tour of East Jersey State Prison, formerly Rawway. And one of the folks that were there was Damon Venable, who was one of the few people paroled at his first eligibility date eventually at 35 years. And Dana Venable, I'm proud to say, is now working for the Office of the Public Defender and our Lifer Group and Parole Project as a paralegal attorney assistant, doing amazing work. And I asked the question, what is the perception of our appellate section? Keep in mind, our appellate section, without question, at least in my view, is the, let me just turn my phone off, is the probably the best in the nation, I would argue. And I know I'm a bit biased on this, but we've had some amazing victories before the Supreme Court and amazing extension of constitutional rights time and time again. But one of the things I asked the group was, what's the perception of our appellate section? And of course, we deal with the cold, hard record of appellate lawyers. You don't deal so much with interaction, unfortunately, with clients. And some of them said, Damon Venable specifically, aloof, real focus on the law, not enough focus on the people behind the wall. We'd like to have more interaction. We'd like to have more view and give more opinions regarding our cases. But he did it in such a professional way and such an intellectually honest way. I sat there and I said, Damon Venable should be working for us. And of course, I did not know at that point in time that he would get out as his first eligibility date. So it was very transformative, that meeting we had with the Lifer Group and with Damon Venable taking the lead among the Lifers. And Damon Venable was very thankful for the work that one of our long-term attorneys, 50 years, Jim Smith, had done on this case. And he went out of his way to talk about the great work that Jim Smith had done on this case. But that was a voluntary meeting with the Lifers. I did not mandate it at that point in time. It was for our newer lawyers and anybody else who wanted to come. But it was so transformative to be behind the wall and to have those prison gates closed behind you time and time again. And it was so sobering that I mandated that every lawyer in our appellate section go to a Lifer group, and we scheduled another one. So we had the second one, and that was before the pandemic. So now, a couple months later, COVID hits. And as a result of that meeting with the Lifers, we decided that the entire parole process really had to be reformed, and the OPD had to play a role in it, whether or not it was amicus or handling high-profile cases, trying to win for the individual client, but high-profile cases, because we can't handle all these cases. We don't have the bandwidth at the present time. Cases with statewide impact that we would handle, and also, of course, most importantly, try to win for the individual client. So we're getting involved as amicus, and then with individual cases with statewide impact, and some of those issues, of course, are right to counsel, getting access to confidential records we've been litigating. And right now we have a case which I cannot discuss because we petitioned for certification to the New Jersey Supreme Court, State v. WM. WM is an individual with serious intellectual deficits and serious mental health issues with a not so good institutional record, because before 2000, the state prisons in New Jersey were not offering a lot of psychological therapeutic interventions. And as a result, folks who had serious mental health issues such as schizophrenia, paranoid type, or delusional disorders were getting into trouble in prison, not because it was intentional conduct, but because their mental illness was going largely untreated. And then in the year 2000, there was a settlement agreement. There's a lawsuit brought by Seton Hall and some other folks against New Jersey State Prison. There was a settlement agreement to give these individuals the treatment that they needed. I'm not saying it's perfect, but it has drastically improved. And we saw a precipitous drop in institutional fractions post-2000 for lifers with mental health issues. And that is something that was very important to the parole project. So I would say the major focus was a sense that the parole board was abusing its discretion, that there was all unpublished cases because the individuals were pro se, not only before the parole board and the parole board appeal back to the administrative body, and that administrative body is the parole board. Think about that for a minute. You have administrative decision denying you parole, and your first avenue of release is back to the very board that just denied you parole. You don't go to an independent administrative law judge. You go right back to the same entity that just denied you parole. Then of course they're going to deny you again because they just denied you, the same folks. And then you take that case on direct appeal. But again, 97% of these individuals, even on direct appeal, are pro se. without counsel. So one of the big pushes that we've made in the Office of the Public Defender is trying to get the right to counsel. And if we can't get it across the board, we are attempting to get it through the legislative process, or at least limit it to those individuals who have serious intellectual deficits, serious mental health issues, and the like. And so that's one of the big pushes of the parole project.
Phenomenal. That was a really helpful overview. I think one other piece that we haven't talked about totally yet is the kind of juvenile lifer piece, right? So how did the relationship between the parole board and the possibility of resentencing hearings impact the work in the beginning, or how is it still impacting the work?
So I was reading a case. I see the gentleman, he's actually on this chat today. He's here. We didn't represent him. He was a juvenile lifer, meaning a juvenile who was waived up. And he had gone to the board, gone to court because he'd been denied parole. He was parole eligible, he'd been denied parole, given a lengthy hit, if you will, or future eligibility term. And he went to the court and said, hey, I should, be able to get out, basically. He went to the court and said, parole denied me. And he wanted a hearing under a case we had called Zuber, that basically said, in the US Supreme Court, there's this case called Miller that said, basically, you cannot sentence a child to die in prison without considering the fact that they were a child, right? No matter, because the vast majority of youth crime, no matter how serious, is what our Chief Justice has said, is the result of the unfortunate yet transient factors of youth, right? And so horrible crimes, but youth are impetuous and they are susceptible to peer pressure. There's these things about the things that come out of the fact that their brain is not yet formed and that they have a different legal status. They cannot extricate themselves from bad family situations and all these different things that are very unique to youth that lead to youth crime, but that most individuals grow out of the things that are biologically or neurologically different about children. And so they are no longer more likely to commit crime, or they're able to extricate themselves from the situations that led to the involvement in crime. And so in New Jersey, we have a case that goes with that called Zuber, and it said, hey, any kid who's serving a really lengthy sentence, even if it's the functional equivalent of life and not actually life without parole, should be able to get a hearing. But the appellate court kept denying people these hearings, saying, well, you don't have the functional equivalent of life because your sentence says life must serve 30 before eligible for parole. They would ignore the fact that it said life. They would say, it says you could be eligible for parole at 30 years. But what did I tell you? Less than 9% of individuals with a potential life sentence were being paroled. And the data, by the way, is not, we can't disaggregate the data to account for juvenile lifers or emerging adult lifers, which are those who are 18 to 20, 25, depending on what age you use, but those whose brain are not yet developed. We can't disaggregate that data because the Department of Corrections nor the courts, no one even thought it was important to name these children as children or these young people as young people. They just were going to be thrown away forever, right? And so they weren't going to be treated as children, which is a whole nother topic. We know that Black and brown children have their childhood stripped away from them at very young ages. So they weren't to be treated as children. But we just have the numbers in total, but we know that less than 9% of lifers are being paroled, and we didn't see that the numbers were any better for our juvenile lifers. And so I was reading this person's case where the court was like other people, denying him, saying no, because you're eligible for parole. And then for some reason, I have a clear vision of it. I didn't have my shoes on. I was reading and I jumped up and ran down the hallway without my shoes on to go to my supervisor's desk, my supervisor at the time, and say, wait a minute, this doesn't make any sense. This is crazy and cyclical. The court is saying you don't get to come to us for resentencing because parole can take care of it. But no one has told parole they have to ever consider the fact that you were a kid. So if the court won't give you a hearing based on the fact you were a kid because you can get parole, but parole doesn't have to consider the fact that you were a kid, who's ever going to consider the fact that you were a kid, right? And so that was one of the first times that we began to really, other people caught on to it before I did, I'm sure, but really begin to understand the ludicrousness of the situation And then that led us to realize how ludicrous other situations were, whether they were based on the person being a juvenile or not at the time of the offense.
Okay, phenomenal. That's a really helpful foray into that part of the history. And I think tease up the kind of next question, and then we'll open up the floor. There are questions already populating in the chat, which is, how has the law around parole in New Jersey changed since you all started working on these issues? What are some of the litigation successes? Are there any other policy shifts you've seen?
Yeah, I think the first case that everyone should review if they haven't already is Bertha versus New Jersey State Parole Board. And the second case is State versus William Thomas. Bertha is a very, very important case. I'm not going to get into the details. Bertha has been released. He was released a couple of months ago after serving many, many years in prison for a murder. Now, the thing about Bertha is that he maintained his innocence through his entire stay in prison and continues to maintain his innocence. And one of the things the court said, that they used that against him for failure to admit guilt, right? Failure to acknowledge guilt, right? And one of the things that the court said in Bertha, and a very well-reasoned opinion by Judge Susswine, that an inmate's admission that he committed the murder is not a prerequisite to parole. Not a prerequisite to parole. That is critical. So in Bertha, the case was sent back to the parole board. And as I recall, in Bertha, which is very important, the appellate division retained jurisdiction. That means you don't have to start this whole appeal process over again. They were so upset with the case that they retained jurisdiction. But the Bertha concurrence by Judge Geiger, who was the same appellate division judge who wrote State versus Thomas, where he was very critical of the parole board, is really a roadmap for our parole project going forward. And there's some great language in the concurrence, because Judge Geiger is very concerned with the unfettered discretion of the parole board. And there's a quote somewhere in one of our cases that says, there is deference to the parole board, and it's an abuse of discretion standard, but that deference cannot be blind. And that is very critical. So one of the things that he says is that, and I just want to quote this, Katie, because I think it's so important. I think it's the roadmap for us in New Jersey for the parole project. And it's a very short quote, but I want to read it to all the participants. Mindful that setting new policies is largely the function of the legislature and our Supreme Court, I respectfully suggest that our Supreme Court examine the board's largely unbridled discretion to impose extended future eligibility terms, whether inmates should be afforded greater procedural rights before extended future eligibility terms are imposed, and whether the imposition of extended FETs warrants closer scrutiny under a less deferential standard of review. Absent such protections, the imposition of lengthy FETs may well violate the fundamental fairness doctrine. And then they quote Thomas. So the bottom line is that Judge Geiger, in his concurrence, is basically asking the legislature and asking the Supreme Court to consider a higher standard of review when an incarcerated person goes before the parole board and they impose a substantial FET. There should be a higher standard of review, because after all, as we started this session, Katie, the parole board is not a super sentencer. They have to give deference to the sentencing judge. And at the time you go before the parole board, you have already served the punitive portion of your sentence. And the parole board cannot give you a new sentence. But we see that time and time again. Shifting to Thomas, State versus Thomas, which was expanded Comer in New Jersey. It was not a per se parole board decision, but Thomas had been before the parole board.
So tell us what Comer was, because I think probably people won't know before you tell us what Thomas is.
Sure. Comer is a case that went beyond Miller v. Alabama. Juveniles sentenced on murder to a mandatory 30 years, were eligible for a look-back hearing, a second chance hearing after serving 20 years to apply the Miller factors to determine whether or not the crime was a result of transient immaturity or irreparable corruption. And in my view, the burden's on the state to show that the person who has served 20 years on a murder case, eligible for resentencing, whether or not the burden's on the state to show that the person's irreparably corrupt. And so we retain neuropsychologists or psychologists to do expert reports and testify at a full hearing. That hearing is not before the parole board. It's important for everybody to realize that. That hearing occurs in court in an adversarial hearing. And so in Thomas, the court said, wait a second, Mr. Thomas was sentenced before mandatory 30-30 went into effect in 1982, because his double homicide was committed in 1980 or 1981. There was a flat life sentence, no mandatory 30, but he was denied a parole hearing because of the case law that said, hey, wait a second, he had eligibility for parole. He went up for parole many times, and he had an opportunity for release. And it's the parole board's determination as to whether or not a person's been rehabilitated. He's not entitled to a Comer hearing because although he got a life sentence, it was not a mandatory 30. So State versus Thomas expanded Comer to say it applies even in flat life sentences when you don't have that mandatory 30 years. And I just want to reiterate, and Thomas, he went before the parole board 7 times, and he got a total of 46 years in future eligibility terms combined. And that was not the intent of the original sentencing judge. Thank God we got the original sentencing transcript. It was on microfiche somewhere. We found it, and it was clear that the judge thought that unlike what the parole board had been stating time and time again, that Mr. Thomas was the major perpetrator of this crime. He was with an older, more mature cousin who only got 10 years. And even the sentencing judge said that I don't believe that Mr. Thomas was the main perpetrator, that we will never know exactly what happened, but there was a more mature person here, his cousin, who only got 10 years and was out or 6 or 7. Mr. Thomas was an electrician in New Jersey and East Jersey State Prison for over 30 years with Mr. Berta. And I'm happy to say that 2 weeks ago, Mr. Thomas was released, and it was a major hug when Mr. Berta was at the gate to meet his friend, Mr. Thomas, and they're both doing extremely well in the community.
Phenomenal. So, we've got a little over 15 minutes left. I think we've got to honor our promise to open up the floor so that people can ask their many engaging questions that are populating the chat and comments, frankly. So I know the first comment we had was from a participant named Ali Muslim. You're welcome to read that comment out loud if you'd like it to be heard by everyone, because I know there may be people here who aren't monitoring the chat. Just want to give you that opportunity.
Well, what I basically said in the chat was, no, I'm speaking from experience. I was 16 when I was incarcerated. I was given 30 to life. When I went up for the parole board, they gave me a 10-year hit. Now they said a significant reason why they gave me the hit was on confidential. No, it was a letter of confidential evidence that came from a psych report. Now, that's what Mr. Russo was speaking about the confidentiality of the psych report. Now, this is the thing. It's confidential to me, but it's not confidential to everybody else that was involved. So if this report kept me inside, why can't I see it to make, to better myself if this was, the reason why? No, that's just something that they use because when I went up again, because I was on good, I didn't get no charges. So and with work time, I was able to bring the hit down to 5 years. I went up again. Nothing changed about me, but I was released. So what was the difference between 5 years prior to that? The other that I have one statement and one question. The statement is when we see these sites, like for my situation, I did 30 years. I never seen this site before a day in my life. They come in, they evaluate you within a couple of hours. They're not that good. My opinion is people who serve that much of time, when they get ready to go up into the parole, like you could say 5 years and see a psych like once a month. This way they have a better understanding of who they're dealing with and they can evaluate them much better than they could in like 1 or 2 hours based on some questions. That's if you really want to be serious about it. Now, the question I have is, what are the qualifications for a person to be on a parole board? Mm-hmm. And the reason why I ask is because if a judge can sentence you and they have to have a law degree and all these other qualifications to become a judge. And the parole board is giving out sentences just like a judge. They should have the same qualifications.
Great question, and thank you for sharing your personal experience with us. I know we all really appreciate it. Alicia, do you want to respond to that question?
We are actually a very industrious, enterprising parole applicant got information on the backgrounds of the parole board members. And I don't mean anything illegal or anything, just like, you know, what degrees they had, what their previous jobs were, perhaps sometimes their political affiliations with the current administration or the administration that appointed them. And, you know, what we found, there is a little bit more diversity than there used to be, but, you know, the parole board has tended to be very law enforcement heavy, number one, right? And we've actually had situations where they had to redo parole hearings because the person sitting on the parole panel had been involved in the investigation of the case of the person that they're deciding parole, right? And let's think about the problem there. Exactly what specialty does a police officer have in recidivism? To a hammer, everything is a nail, right? Was there any special training on preventing recidivism or on recidivism rates or any of that? Right? We don't have, you know, we don't see necessarily that there are specialty trainings that these individuals, you know, have training specifically that justifies, you know, you will see these opinions from the appellate division, where we give deference to the parole board for their expertise. What expertise? Tell us what that expertise is. Is it because they were a donor to the government? Like, what is the expertise? And one of the clearest examples we have are in some of our sex offense cases, because in sex offense cases, at least certain ones, because they recognize, oh, there does need to be an expertise of some sort, right? They think, okay, well, those are sex offenses. We have specialists to handle that. There's actually a board under the parole board that does the recommendation of whether or not the person should be paroled. And we have situations where that board that does include psychologists and people who have specialties in sex offenses, you know, analyzing sex offenders and things like that, they will say, yeah, we looked at everything and this person is ready to be released. And they're the special board that the government set up because these are special cases. They will then make that recommendation to the parole board. And guess what? We have cases where the parole board then says, nope, we don't think they should be released. And when those cases go up to the appellate division, what do you think the answer will be? We defer to the expertise of the parole board. Well, wait a minute. But the government set up a board under them in acknowledgement of the fact that in this set of cases, they definitely don't have expertise, right? So this is a problem again and again. They don't have, I'm not saying none of them do. I'm not saying they don't take any classes, but from what we've learned, and we don't know about everybody and everything, there is no special expertise that makes this panel in a particularly good place to make these determinations. And we know they're not following the science. We did have an addition of a factor to consider maturation during incarceration. They agreed to include that as a factor. And then when one of our partners asked, but this is going to be a mitigating factor, right? Something that will lead to more people being released. They answered us boldly and loudly, oh no, we reserve the right to decide if maturation or lack thereof in prison is an aggravator or a mitigator. Gave and then you took away.
That was a phenomenal response, and I just want to, Mr. Muslim, was a phenomenal question, and I'm really glad you're doing well. So I just want to comment on this, and Alicia raised a great point, deference to the expertise of the board. We see that time and time again in these unpublished appellate division opinions with pro se litigants, that we defer to the expertise of the parole board. What's interesting is that the expertise of the parole board oftentimes is allegedly with the psychological evaluations that our clients don't see. So if it's a positive psychological evaluation, oftentimes it's ignored. And it's a negative psychological evaluation, it's embraced. And remember, I said that the parole board can't cherry pick. They can't minimize favorable evidence or overlook clearly favorable and exculpatory evidence, but that is done on a regular basis. We're seeing some improvement in that. But these psychological evaluations, it's very important if there is an attorney involved, which is rare, but it's very important for the attorney to discuss that with their client, unless there's some direct threat to the psychologist or the institution as a result of the evaluation, which frankly I've never seen. But I think that's one of the reasons why we started the Parole Project, was because, you know, everything's done, there's no transparency, everything is opaque. And somebody said along the line that the sunlight is the best antidote, the best prescription for democracy, sunlight, you know, and we need to have sunlight into the process. And what I mean by sunlight is knowing what all the backgrounds, the incarcerated person who got the resumes of the parole board members did it through an Open Public Records Act request. Okay, it was really great that he did that, but we need sunlight on the entire parole process. And unless there's some danger to somebody as a result of some psychological evaluation, there should be a presumption, just like there's a presumption of release, a presumption that the incarcerated person has access not only to all of the records, but the psychological evaluation, which is often the basis for denying parole, when in fact it should be a basis most times for granting parole. And so I think Mr. Muslim raises a very good point, and deference to the expertise of the parole board. The question is, do they have the expertise? And if they retain an expert, why don't they rely upon those expert reports, especially when they're favorable to the incarcerated person?
Yeah, really terrific answers. And I just added another layer of, concern that comes out of a body of research around this. So there was a study done in 2022 about racial disparities in life or parole outcomes in particular, finding that professional evaluations and deference to those professional evaluations was a driving factor in disparities, that people were engaging in treatment and rehabilitative programming in similar rates across racial demographics, but that the disparity was explained by this kind of over deference to these professionalized judgments or perceived as professional judgments, including psychological evaluators, but also prosecutorial recommendations, right? And to the extent that you're raising questions, lots of Ali Muslim is raising questions, but also Alicia, I think your response certainly raises questions. What expertise is being offered here, right? When it comes to prosecutors who are in the business of charging offenses, but not evaluating rehabilitation, that's just not their training or their expertise. The deference to those kinds of evaluations, I think, is particularly concerning also. We've got lots of other questions, and in particular, Michael Osterman has asked a series of questions. Michael, can you start us off with your questions about kind of program access? If Michael's still on the line.
Yeah, he said that his mic or camera.
Oh, okay. So in that case, I will read these questions so we can all hear them, because in case somebody's joining by phone. So the first was, have rehabilitative resources in incarcerated settings decreased over time, or have populations increased with resources staying the same or decreasing, which could potentially preclude incarcerated people from adequately engaging in their own rehabilitation and thus decreasing their likelihood for release? So do you all have a sense, have you done any investigation about kind of availability of program access?
Yeah, I'll give, because we have limited time, I'm going to give a story that I think, a real quick story that I think answers this question, it lays out the problems. So first of all, we know, before I say that, during COVID, there was a dramatic decrease in the services available, and that's been a problem. Services are starting to come back online. What we also know is that sometimes those with the longest sentences are placed in institutions that get the least amount of resources. And so that's also been a problem. And it's also talked about in some of the cases. So you have people in institutions and then they go to parole, and parole says, you didn't take this class and this class, that class isn't offered. So the story real quickly is, there's an individual that I know who is actually, he is a graduate of the wonderful New Jersey STEP program, which is a college program in our state prisons. The program is basically run by Rutgers University. And so one day, the person is a graduate, the person is now in a master's program and in an inaugural master's program. And the person called me one day very excited because he had finally been accepted into this class called Focus on the Victim. And the parole board oftentimes wants you to take Focus on the Victim. Sometimes the person is taking it and the parole board recommends they take it again, right? Just they like that class. That's one of the things they look at. And this person was so excited because they finally got into Focus on the Victim. And I said, wait a minute, hold on, because I knew the person. Said, what year did you start your bachelor's? Well, your associates, they start the associates first, and he told me the year. And then what year did you go into the bachelor's program? And you graduated and you got accepted. You've been on the wait list for Focus on the Victim the entire time. Are you telling me that in the New Jersey Department of Corrections, it is easier and faster to get an associate's degree, a bachelor's degree, and get halfway through a master's program than it is to get through the Focus on the to get into the Focus on the Victim class, just to get into it? And so we have a major problem with people not having access to the very things the parole board will then point to say, you didn't do this, or you need to do this, and that's why we're not granting you parole. Now, to be sure, and to be honest, when the people do complete those things, the parole board comes up with other reasons. But the fact remains, let's not hand to them on a platter rationale to not provide parole.
Yeah, and I just want to give a quick shout out, which I don't typically do, to the new ombudsman, actually, for the Department of Corrections. I know this is unusual for a public defender, and I forgot his name. Alicia might recall it, but he's doing phenomenal work. He has met with many of our lifers. He has met with the Office of the Public Defender on many occasions. And I will say the NJ STEP program is a phenomenal program. I wish it was in every one of our state prisons. It doesn't seem to be in some of them, but it's definitely in East Jersey State Prison, Northern State, Edna Mahan, and maybe one or two others, but it's a phenomenal program. And it's just, I can't say enough about it. And I really can't say enough about this new ombudsman with the DOC.
Is it Terry Schuster? Yeah.
Terry Schuster. Yes, it's Terry Schuster.
Phenomenal. Okay, we've got a hand up from Anton Henshaw. Anton, go ahead and ask your question.
It's a question, but it's also a statement. One of the things, I'm also an emerging and adult lifer that was with a lot of the people that were named in Alicia's and Joe's presentation. So one of the key things that when we were inside and we were doing the research was making sure, like, the racial disparities of these decisions being carried out. And there is no racial impact statements to a lot of the decisions that our parole board makes in New Jersey, right? That these decisions are not broken down based on one's race. They don't even keep that stat. So so my question would be, and going forward, like, I'm a transformation agent. So how do we transform these systems to really show and demonstrate how, in that 15% of our state's population, how disproportionately these parole denials affect the people coming from communities that I've grew up in that's all over the state.
And that was one of the recommendations, actually. Thank you, Mr. Henshaw, and thank you for all the great work you do. I know Mr. Henshaw is an amazing human being. Let me just say something, two things. Number one, New Jersey has problems. We want to be known as the state with the best pizza, not with the state with the highest racial disparity. And the sentencing project just came out with new data, which once again shows that New Jersey has the highest percentage of Black and brown people incarcerated in our county jails and in our state prison of any state in the entire nation. And one of the recommendations of the Parole Project was to take a look at racial disparities. And we have to get that data somehow. We still don't have the data. We have a lot of work to do in New Jersey, despite all the great things that criminal justice reform did in terms of reducing our county jail population by close to a third, around 30%. We still have the greatest percentage, again, of Black and brown people incarcerated in our county jails and in our state prisons. And it's a major issue. I wish I had an answer, Mr. Henshaw. I don't, but we need to somehow get a hold of data or aggregate the data and take a look at what the parole board is doing and the racial disparities in granting and denying parole. Alicia?
I was going to say, and to add to that, granting and denying parole, but also part of the discussion, I know that you went an earlier segment of this series was on not mass incarceration, which people tend to focus on that, but that's only one part of the carceral system, right? It was on mass supervision. And so it's on the granting and denying of parole, but also on the granting and denying of discharge from parole. Because in the situations where our clients do manage to get out, or our former clients, on parole, many of them are facing parole for life, right? And so that's another area where there's this concern, again, with parole on what is the racial breakdown of who's granted or denied release from parole. These are more than mere inconveniences to remain on parole. You want to get on parole, right? You want to be out. But then we know, and many studies tell us, parole is best if it's going to do what it's supposed to do in theory. Parole is best for a few years and then you're done, right? It's supposed to be the bridge between inside and outside. It is not supposed to be a way of life. And yet we know of individuals who did 24 years, have been on parole for 24 years. Mind you, on parole, having retired from government work, right? Did a sentence for a really long time, managed to get a government job, retires from that government job, is a senior citizen, and is still on parole, right? So we have some grave concerns as well about what are the racial dynamics or other criteria for denying discharge from parole.
And that was the question raised by our friend Tony Hayes in the chat. People who are on a lifetime of parole can apply to get off after 7 years. It goes back to the parole board. They typically deny, and then you can go to the appellate division, but there's no representation of these individuals. It's de minimis, maybe the ACLU, maybe a clinic. The Seton Hall Clinic does great work, the Rutgers Clinic, but there's very few entities will take these cases on a pro bono basis. And so they're without representation again. And that's a major issue looking at the data regarding discharge from parole, because it's a continuation of the carceral state. That's all it is.
And we've got good questions from Ricky on that same topic in the chat. And hopefully, I think you both have just spoken to that question. I think our last question, unfortunately, is going to have to be from Cosimo. Go ahead. You've been waiting patiently with your raised hand.
Hi, thank you. Thank you, Mr. Russo, Ms. Hubbard, for taking the time.
Good to see you again, Cosimo.
Good to see you, Mr. Russo. Quick question. You spoke a lot about the need for more transparency and predictability in the parole process. To what extent, if any, do you think automated systems for determining parole release decisions could be useful? And in light of, I know a lot of potential implementations that have resulted in exacerbated algorithmic bias issues, things like that. I'm aware of that, but I'm curious to know if you think that automated systems could play a role in increasing the predictability and transparency of parole release decisions.
Joe, I'm going to buy you a minute to think about that.
Thank you very much. I do appreciate that.
I'm here for you.
That's a tough question.
As I start with, just so that everybody, because I know everybody on the call is not necessarily a lawyer or is not familiar with the algorithmic problems that Cosimo is referring to in this question. So some New Jersey and some other states or entities have gone to moving away from, for instance, a cash bail system pre-trial to what they call a risk-based system. And they determine risk by an algorithm set up with a computer program, right? And they put in the number of priors, the number of this, the number of that, what your ties are to the community, et cetera. They come out with a number or a letter or a number combination letter, or whatever, and say there's this risk. And if you fall into this category, then we're going to recommend that you be held before trial. And if you fall out of that category, you won't be. These types of things are used in some way, shape, or form in other aspects of the criminal legal system as well. And one of them is the LSIR, which is not necessarily calculated by a computer. It can be, it's a set of questions, but you get a certain number. Unfortunately, there's bias built into the number because but you get certain, you get points for certain questions, and then they add up, and depending on what your score is, they determine your risk of recidivism. The problem is that these scales have built-in bias in them. So for instance, if we know that Black and brown people are more likely at every stage in the criminal system to be treated worse, right? We know that they're more likely to have police contact, whether or not they committed the crime. They're more likely to actually get arrested, whether or not they committed a crime. Then they're more likely to be convicted, whether or not they actually committed the crime. Then they're more likely to get a longer sentence, whether or not they committed the crime. By the way, we now know that they're more likely to get a longer sentence, even among Black people, the darker skinned you are, right? So like all of these things, right, are building in bias. And so that bias gets built into the supposedly objective measure or the algorithm. And so that's the concern that Cosimo was saying, like he knows that that's been an issue. However, if we want to have a more objective standard, is there a role that a computer or algorithm can play in order to create a less biased situation? So Joe, now your thoughts on that.
Thank you for giving me a little time to get my act together here, Alicia.
We've worked together a while.
So I just wrote a few notes down. The politics of the LSIR score. That's the risk assessment tool that's utilized in New Jersey and in many states. And what I say the politics of the LSIR score, because I deal primarily with lifers along with Alicia, mostly juvenile lifers, but not all. There's an inherent bias against lifers, especially juvenile lifers, because you take a look at their employment history. Okay, your employment history. Now, why isn't employment in prison taken into consideration? Why isn't educational programs in prison taken into consideration? So the LSIR score is inherently biased when it comes up with a score for whether or not you're minimum, medium, or high risk of recidivism. Of course, if we have a low LSIR score, we embrace it, and the parole board oftentimes, unfortunately, rejects it. And if it's a high score, of course, they embrace it. So it's the same issue with the psych reports, you know. So, I don't know. I think we have to get beyond the LSIR score to something more sophisticated. We have to make sure there's not race bias or other types of biases inherent in the algorithm. Because, for example, even, criminal justice reform has been very good, and we do have an algorithm that's being utilized. So it's not based upon any interview, but also that has an inherent bias in it because you're looking at the history of prior offenses. And your history of prior offenses is tied into systemic and institutional racism because of the decision on the cop on the beat to make the initial charging decision, and the white kid on OxyContin in the suburbs, may never be charged, or they may, walk them down for a station house adjustment. Whereas the kid from the inner city on the so-called other side of the tracks is going to catch a charge. And then, so, you can never get over bias, but, I'm really interested to pursue this further, this whole idea of an algorithm and the parole process. There's something else I wanted to say. When I attended Jim McGreevy's, one of his reentry programs, Michael Williams was there, who has since passed away.
Jim McGreevy, former governor of New Jersey.
Yes, thank you. And he does some great work with reentry, and I was on the initial board, actually. And Michael Williams, from The Wire, who has since passed away of a drug overdose. I saw him speak a couple years ago, and I have the video saved. And he went up there and he said, where were you all when I was addicted to cocaine, what they called crack cocaine in the day? Where were you all then? When I was seriously addicted, it was a criminal justice problem. And now it's become a healthcare issue. And it only became a healthcare issue when addiction and OxyContin permeated the white suburbs. Then all of a sudden it was a healthcare issue. But for decades and decades and decades, it's been a criminal issue, a criminal justice issue, and we tried to incarcerate our way out of it while the white population went largely unscathed. And we need to take a look at that. Race is a major issue across all of this, and we need to somehow get a hold of data and do a deep dive into it.
Well, that is a perfect note for us to end on, unfortunately. This has been a really rich conversation. Thank you both so much for your participation and for your knowledge and expertise. We're going to all be following your litigation wins, and hope you'll keep us updated about if that case gets accepted for certification, when we can watch your argument. And looking forward to continuing to kind of cross-pollinate work. So thank you all so much.
And Katie, thank you. And just before we go, I want to say, I'm glad we're going to go because Joe and I need to go make sure we're home and rested, because we have to be up early in the morning, because one of the people working with us on this team, we've got to meet her as she and some other people on this call, as she welcomes home her client who was denied parole several times and will be walking out tomorrow morning after serving 50 years. So this work is important, whatever state you're in. This is about, as one of our colleagues says, time saved. It's about lives saved. It's about the opportunity for people to rejoin the community. So I just wanted
That's right. Shout out to participatory defense for that. Yes. Time saved versus time served. Exactly. Yeah. Right. That's right. All right. Well, thank you all so much. Take care, everybody. Have a good night.
Bye.
Good night.